All rise, please. Circuit Court will now come to order. Governor Robert K. Rouse Jr. presiding.
Thank you. You may be seated. Be at ease. Thank you. All right. Good morning and welcome to the Circuit Court here in Volusia County, Florida. We're gathered in a case that has been filed recently entitled Richard S. Gardner, plaintiff versus Volusia County, Florida, and George Rechtenwald, defendants. It's case 2012-10167-CIDL. So that is the matter on which we are convened this morning. Now, I just got delivered to me today, actually, the file from the clerk's office. I guess they were putting it together. Here's the paper file in this case. And when was the complaint filed?
Tuesday, Your Honor.
Yes, January 17, the complaint was filed, and a request was made that we needed an emergency hearing on a temporary injunction matter. So I said, well, counsel were telling me there's an emergency, let's try to go with a quick hearing. So, of course, here we are on January 20, which is, I guess, depending on your point of view, quick or not. I tried to make sure everyone, including the defendants, knew about it, but I'm not sure that got done. I have now received some correspondence in the form of actually not correspondence, but a response. I think it was called, yes, a motion for protective order is what it was called, from the county with regard to this matter. So obviously, as they say in that motion, they did find out about it. I also received yesterday afternoon at about sometime in the afternoon, I learned about it on a break hearings that I was involved in yesterday. I received this material, which is, I don't know, 5 or 6 inches deep of documents and the like, apparently for me to study and memorize before our hearing this morning at 10:30. And I probably because it's no shock to anyone that I haven't had a chance to do that. I did read the petition for temporary and permanent injunction and the County of Volusia's motion for protective order. And I went back and briefly reviewed portions of chapter 112 and of course the rules, Florida Rules of Civil Procedure with respect to injunction proceedings. So that's the preparation that I managed to do before we arrived here moments ago. I'm sorry for a short delay in getting started. I'll try to give you the full time that we had indicated if needed. So if we could start, because I see we have a court reporter, we could start with Ms. Jones, go across and have everyone identify yourself and tell me what, if you expect to speak or be heard in this matter, who you represent, and then anyone else who's in the room, if you're not here to participate and to speak, we don't need you. These are public hearings. Nobody needs to identify themselves. It's not expected or required. If anybody wants to, for some reason, if you need to, then just raise your hand and we'll let you identify yourself also. All right, Ms. Jones.
Yes, Your Honor. Good morning, Judge. Nancy Jones on behalf of the defendants, Volusia County and George Rechtenwald.
All right.
Giffen Chumley, Volusia County Attorney's Office on behalf of defendants at Volusia County on behalf of George Rechtenwald.
Your Honor, Jake Caney from the law firm of Caney and Oldbury in Ormond Beach on behalf of what is the petitioner, but I put plaintiff on the petition, Richard S. Gardner, and I also have with me co-counsel.
Your Honor, Abraham McKinnon, also on behalf of the petitioner, Richard Gardner. With us is our client, Richard Gardner, who's here today, who may testify in this matter.
All right.
Judge, if there is any testimony, I might be called upon to testify. My name is Larry Smith, the Deputy County Attorney. So I'll identify myself.
All right, welcome one and all. Now, let's go over the rule on injunctions, Rule 1.610. Says a temporary injunction may be granted without written or oral notice to the adverse party only if it appears from the specific fact shown by affidavit or verified pleading that immediate and irreparable injury, loss, or damage will result to the movement before the adverse party can be heard in opposition. And the movement's attorney certifies in writing efforts have been made to give notice and reasons why notice shouldn't be required. And then it says, number 2, no evidence other than the affidavit or verified pleading should be used to support the application for a temporary injunction unless the adverse party appears at the hearing or has received reasonable notice of the hearing. Interesting the way that's written in the disjunctive. Every temporary injunction granted without notice, et cetera, et cetera. All right, so this one is now a temporary injunction with notice. I'm not sure we can talk about the adequacy of the notice, but obviously it's not being done without the knowledge of and without any notice at all to the defendants or respondents. Because you're here, Ms. Jones, representing both defendants? Or?
Actually, yes, Judge, Mr. Chumley is lead counsel and I'm second chair.
Okay, Mr. Chumley. I always just assumed that.
I'm a new face, Your Honor.
That's, I'm pleased to meet you, Mr. Chumley. I didn't think we had met, but I sometimes forget when I've met people. In any event, I'm not sure, Mr. Kenney, in fact, I'm pretty sure, Mr. Kenney, Mr. McKinnon, that I'm not going to conduct a full evidentiary hearing here this morning in the hour and a half that I had set aside for this temporary injunction, having no idea that it involved all of this. And with such short notice to the respondents, because they have asserted that they haven't had an opportunity to fully prepare, and they were shocked and surprised by this action, and apparently had time to put together this very well-drafted, neatly word-processed motion, but no time to do much else, according to them. So I don't think we're going to have any full evidentiary hearing. Therefore, I'm not going to probably permit anyone to testify, either your client or Mr. Smith or anyone else. We'll just have to set that off for a different time if it looks like it's going to be necessary. But the questions I had, even before I got the county's response, after I had read your petition, was is your, well, let me just explore this with you. And then I read the statute. It appears that the statute is designed to protect law enforcement officers and certain designated people. That if there is an investigation that is asserted to be an unfair or improper investigation of some kind, I can't remember all the words that the statute uses in that regard, but in any event, the person being investigated, let's say the law enforcement officer, may request a compliance review panel conduct a review. That's the name, I suppose, compliance review panel. That may hear evidence review, documents, hear argument, and then if there's an intentional violation, I guess, of the rights or whatnot, the agency head would remove the investigator who's investigating the officer. So we have an officer being investigated, the officer thinks it's not an appropriate or fair investigation, it's intentional misconduct, asks for a review by the compliance review panel, and the compliance review panel would recommend to the agency head or make reports and findings, and if they say it's appropriate, then the agency head would remove the investigator. Is that your understanding of the way this works, or have I misread that?
There's a little more to it, but I think what you said